Good morning, folks. Today I've got something a little different for you. It's the Siberian tiger going to his arraignment. The title of his video is Arraigned Again, so I'm assuming he had one arraignment that didn't go very well, so they've got to have another one. I don't know. I haven't watched this yet. It's about 30 minutes long. It's a court cam video. So I know the first 10 minutes is him just sitting there wrapped in a flag, which is ridiculous. But anyway, let's go ahead and check it out.
Hi there. Mr. Krivolenko, you can go ahead and sit at that table over there if you like.
If you get a little cape on, it's a combination of the American flag and the Jewish star. Oh yeah, he looks real good today. He looks real good, ready for court.
Okay, so there's some preliminary kind of housekeeping things that the court has to take care of initially. So I'll let you get set up there and then we'll go ahead and start with those. Okay, so Mr. Krivolenko, first things first, I couldn't tell from your initial appearance in district court, which I wasn't present for, whether or not the judge went through this colloquy with you regarding an attorney, because I did note that you did have an attorney representing you, it looked like in Superior Court. But you do have the right to have an attorney represent you in this matter. If you cannot afford an attorney, one will be appointed for you at little or no expense to you. The maximum penalty on both charges is 1 year in jail and a $5,000 fine. You may be at a disadvantage in representing yourself, as a lawyer knows the court rules, the evidence rules, the laws that apply to your particular case.
Wow, he decided to represent himself. This is going to be a nightmare. I hope he films the whole trial.
Those rules and laws may be technical and complex. You may not understand them without the assistance of an attorney. Keeping in mind the dangers and disadvantages of representing yourself, is it your desire, number one, to represent yourself, or are you asking for an attorney to represent you?
It is my desire, Judge, to represent myself as a pro se.
Okay. And are you making that waiver of your own free will?
I do.
Anybody threaten you or make any promises to get you to waive your right to counsel?
No.
Okay, if I could just have you come sign the pen pad in regards to that. Oh, it'll be just a second. I'll pull you up here later because she has to fill out the paperwork. Okay. Then the second issue, still on Leonid Krivolenko. Today is the day set for your arraignment, which is where you would either plead not guilty to the charges or plead guilty. So is it your desire to plead not guilty to the 2 counts?
It is my desire to enter into record a plea of not guilty on all counts.
Okay. Do you want me, did you receive a copy of the citation that was filed in district court previously?
A copy of citation or
Yeah,
a copy
the
of a complaint?
Complaint. It looks like you have it there. It's like a 2-page complaint charging you with harassment and obstruction of a law enforcement
I do
officer.
believe if you're referring to the same one that has been filed on 9/23, is that the one you're
Yeah, that's what I'm referring to. Do you need me to read that out loud, or is that something you've been able to read to yourself?
No, it's fine. We can
Okay.
proceed.
All right, so not guilty plea will be received. And then there is, there's a couple of housekeeping matters, but also there's the matter of needing to set Mr. Leonid Krivolenko's trial dates. I did note upstairs in Superior Court that the last speedy trial waiver entered was effective commencement date of July 1st, 2024. The dismissal without prejudice order upstairs was August 12th, 2024. So my calculations, that would be 42 days elapsed with 48 days remaining on speedy trial. There's a motion to consolidate your trial with Victoria Krivolenko's trial so that there would just be one trial and not two separate trials.
This has to be for the incident at his house when they came to tow his car and he and his wife threatened the tow truck driver, blocked him in and all that stuff. That's got to be what this is.
So I'll start with Leonard. Do you have any objection to that motion to consolidate?
I do not.
Okay, and then Victoria, Vika, do you have any objection to having your trial consolidated with Leonard? So it'd be one trial instead of two separate?
I do not.
Okay, so we will go ahead and consolidate. Now, Victoria Krivolenkov's trial is currently set for November 7th. And that's a little quick, considering we just arraigned Leonard, but I know the case had been around upstairs. So I could also set you for November 7th, Mr. Krivolenkov, or within Speedy, if you don't want to waive. We have 48 days remaining from today's date.
Well, Your Honor, so that's the only thing I want to make sure we're clear with the record, and Mr. Krivolenkov. The way we looked at the rule, and maybe the Superior Court rule is slightly different than the limited jurisdiction rule, but when we filed the case, it was when Speedy started for us, is how we read it. Did you read it differently? So that's why we scheduled our filing, so we had about 40, we have about 3 days left over from November, like, to my calculation, Speedy expires on November 10th. If we follow the, but if, so once we refile.
So you're saying he has less Speedy than 48
Yes,
days?
yes. So we read it a bit more strictly.
Okay.
Since we had dismissed the case in Superior Court, we refiled it in District Court. We don't, it's the state's position that we don't necessarily get to start at arraignment, like it would be if it was a brand new case. We start from the date of
Oh, okay.
filing.
I didn't go into it in that much detail.
Well, and I
Okay.
want to just, yes, I want to be as
Is the
clear.
November 7th date then within Speedy by your
Yes.
calculations?
Yes,
Okay.
we'd have 3 days left over.
All right, sorry.
Thank you.
I just know quite a bit of time was chewed up. So we can set you for November 7th if you think you're ready to go to trial on that date, or I can set it out a little bit farther if you want to waive speedy trial.
I'm going to object to what the state is proposing, and I think the state is mistaken about the dates. This is a brand new case. Whatever happened in the Superior Court is not relevant to what is happening to this case, because they refiled it on different charges.
Yeah, I get that, but it is as far as speedy trial is concerned.
And
It is a separate case, you're correct, but it's a same incident continuation of your speedy trial.
Well, I'm going to disagree with the court opinion about that. Irrelevant to those facts, irrelevant to that procedure of the rule. Obviously, I can't be ready within a very short period of time because there's certain evidence that I need to prepare, and the state has not produced the requested discovery. So that's still an issue outstanding that the state has to oblige by, and it's the state's responsibility to do so.
Okay, what I've gathered so far is they had dropped the charges and then recharged him. So this is a second attempt at a trial. He wanted a speedy trial, but now he wants to change it because it's happening too fast. That makes perfect sense for this guy.
So you're asking for a trial date farther
Settled.
out than November 7th?
I most certainly do, Judge.
Okay, so that would, I think there are proper grounds, obviously, you just were arraigned today, even though the same allegations have been around for a while, as far as the incident, different charges though.
So, I am proposing that the court issue an order for the state to comply with discovery rules by November 8th, the deadline.
They should be able to do that.
And I'm also proposing that the state allow me, obviously, to submit my dispositive motions or motions to dismiss or otherwise other motions.
Yeah, we're gonna schedule those today, because I saw Miss Victoria Krivolenkov filed a new, I think,
A new motion, correct? Motion
a
to
new
dismiss.
motion, yeah, so we're gonna have to schedule that as well.
Right. So I think we probably should look for a trial date sometime late November. Maybe we can start the first day on the 22nd.
Oh my, he thinks he's running the court here. He wants to set his trial date for a certain date. I don't think the judge is going to go for it.
I'll tell you the available trial dates I have are December 12th, 13th, 19th, or 20th.
How about December 20th?
Does that, Miss Victoria Krivolenkov, does that work for you?
That works for me.
Right, and I think you waived as of today's date, so we should be okay. And he's requesting a continuance, so I think that makes us okay on his as well.
So your honors, is he acknowledging and waiving his speedy trial right?
I'm still within my time period, I'm not waiving my rights.
He's asking for, well, I guess it's not a continuance, right?
Well, set over continuance, but I'm still within my,
Because I guess also too, the state want to inquire, he was given all the discovery as part of his felony case. There's no additional or new discovery that we have.
Actually, you're not correct, Counselor. I requested, I specifically requested that the state turn over all known individuals, all known material witnesses. There is on record an outstanding material witness, tow truck individual male number 3, who's not identified in any of the police reports. He was interviewed by the officers. His statement was taken on record on video on Deputy Fisk's, my arresting
Do you know
officers.
the name of that individual?
Mr.
I do not know anything about that individual, and it is responsible of the officers to conduct investigation and turn that information over. That
Okay,
is a statutory
hold on one second.
requirement.
All right, let's back up for a
Yeah.
second. Let's find a trial date, and then we're gonna go through some of
Sounds
the
good, but-
discovery issues that
So
you.
your honor, I apologize. Could we move the trial back to your 12/13 date? We have a conflict that we're already aware of on your 12/20 date.
Oh, December 12th or 13th.
Yes, does either
Is
one.
there any issue with December 12th or 13th for trial?
That's a conflict with me as well, Judge, because I have other matters, other jurisdictions to attend to. So yeah, that would be a conflict for me. I won't be ready by that date. So the 20th is more feasible.
Right, but we need to make sure witnesses are available for both sides. So if we can't find a date in December, then we're going to be looking at January. And the earliest dates I have in January 9th and 10th. Would require a waiver from both parties to go.
Oh, I'm not waiving my speedy trial rights.
Well, then, the only choice we have is to set within current speedy trial, which is November 7th.
And your honor, I guess.
That
I
will
could-
work.
Okay.
Okay.
We could try.
No, excuse me, Judge, I thought you were talking still about January. No, my apologies. No, November 7th will not work, so we'll have to, the court must, I mean, if you want to.
No.
As far as I know, I'm sorry, I'm going to interrupt really quick. As far as I know, that was December 16th.
I don't think I have December 16th in my calendar.
You gave 4 dates.
Yeah, I gave the 12th, the 13th, the 19th, the 20th.
Oh,
So that-
19th is fine. Let's do the
There's a
19th.
19th and 20th
No,
do
we
not
have,
work.
sorry, we have the person, because I'll be out on leave, so the person taking over is out of the office on the 19th and 20th.
Okay.
Your honor, at this point, I think the state can hopefully simplify things for the court. And for Mr. Krivolenkoff, I don't think we're going to be proceeding with the harassment count. Not because the state doesn't believe they have a good faith basis, but more we have witness availability issues. That said witness and listed victim has moved to Yakima, and we don't know that we'll be able to seek him. So we'll just plan to proceed if he doesn't want to waive his speedy on November 7th with just 1 count of obstruction from him, 1 count of obstruction from Ms. Krivolenkoff. The state only intends on calling about 3 witnesses, Deputy Fisk, Deputy Agar, and Deputy Freudenberg.
Well, are you dismissing the harassment count?
Yes, without prejudice at this time.
All right, so we're going to enter an order dismissing count 1 today, based on what she's saying. So now we're just left.
With prejudice, I assume, Judge, right?
Without.
With-
Because,
I
yeah, because
object.
there's no prejudice that's attached as of
Well,
this.
then I'm strongly raising my objection that if the state is proceeding that way, the state then must dismiss the entire count of harassment. Clearly, I've already introduced into record exculpatory evidence. There should be no reason for the court or the state not to dismiss it with prejudice. So if the state is not willing to dismiss it with prejudice, we are going to trial on that count.
You can't force the state on what they charge you with. They can
Well,
dismiss it.
I would like my
They
objection
control.
to be noted
It will
and
be,
put in the record.
and the closer we get to the trial date, if the harassment hasn't been addressed, then, yeah, you're going to have a better argument regarding with
Well,
prejudice.
that's why we need to hear my motions first, and then if the state has any objections, they can raise them, but
Okay, so that's a different issue. So, count 1 will be dismissed without prejudice. Count 2, which is now the obstruction of law enforcement officers, still remaining. Okay, so for us to be within the rules, so let me read the rule first off on 3.3 on time limits to make sure you are, because I was thinking I had 48 days and that might help me, so. Okay, so it's considered a related charge, right? All right, so time for trial. So commencement date, resetting of commencement date.
This judge has no idea what kind of nightmare she's getting herself involved here. He's going to try to stretch us out as long as he can and make them violate the speedy trial, which is, of course, going to backfire on him because he's an idiot and he doesn't really understand how everything works. He's pretty smooth and calm, at least. He's not flipping out at the judge, so I'll give him that much credit.
Handcuffs are applicable. E. Okay, so you were going under, I suppose, E4, period between dismissal and filing. The following period shall be excluded in computing the time for trial. And then E4 says, the time between the dismissal of a charge and the refiling of the same or related charge. So that's excluded.
And so trying to look at it like most favorably to speedy trial rights, we're trying to be as strict as we can to the state. Once we refiled, we had to kind of get this going.
So once you refile, then we go under the arraignment, right? Oh, I see what you're saying, between dismissal and filing.
Right.
I got you.
Between August 12th
Okay,
and
when did
September
you
20th.
file on this case?
I think it was, Mr. Kovalenko had it right, I think it was September 23rd.
Okay, so it started back up again September 23rd, is what you're telling me.
Yes.
So between August 12th and September 23rd was told.
Was told, and then once we filed the case again, because that's kind of from an original charge, we picked right back up where August 12th left off. They gave us 48 days. November 7th is 45 days. Yeah.
Well, you're confusing me. So his last waiver.
Was for July 1st.
Right.
And then
you
we
dismissed August 12th.
Right.
Which to me was 42 days.
That's what the state had as well.
Okay. And then September 23rd, Speedy started up until today's date, right?
We have counted
Well,
Speedy as
actually,
started.
Speedy started September 23rd.
Yes, that's where we're at.
Okay.
And then we
And then
counted.
I just have to figure out how many days were from September 23rd to today to figure out how many days left.
Oh, yes, left over, yes. I shouldn't say purposely. We knew Ms. Krivolenkov's case was November 7th. That seemed like a reasonable date. We were going to try and consolidate. It made the most sense. So we counted back.
So today is October 21st. So that would be, it looks like 28 additional days on top of the 42. Is that what you were showing to today? Oh, you never mind. You've got it different.
I calculated, sorry, from November 23rd to
So I
November
have
7th.
70 days elapsed. I'd have 20 days from today.
20, yeah, that's
Does that, so that comes out to be,
42.
maybe it's not the same as yours. It comes out to be November 10th.
Yes, yes, we're on the same page. Sorry, I had always been calculating from your trial dates because I know the court has specific trial dates, so we had made sure to file within the November 7th timeline.
Okay, and so so I can set the November 7th date, and then Mr. Krivolenkov has a right to object that, that November 7th needs to be continued because that's not gonna give him enough time to prepare. Is that correct, Mr. Krivolenkov?
That is correct, Judge. That is my position.
So then I think we get into another, because he's asking for the set over. Let me find where that is. Resetting of commencement date, right?
But I am not going to waive my speedy trial rights. So if the state cannot fit that in the schedule,
Well, I can
dismiss the
set
charge.
it for November 7th, which is within speedy. And the only way we get out that is you either ask for continuance, in which case I think that gives me more time because the excluded period is between the time of the continuance and the next trial date.
No, then we're gonna stick, then that's fine.
So you want November 7th at this point?
Do you have something available on November 8th?
I think that's a Saturday.
That's a
Let
Friday.
me look and make sure. Oh, November 8th, yeah, she's set for the 7th, but November 8th is a Friday. Is that doable?
We had confirmed their witnesses for November 7th. We certainly can try for November 8th. If not, we'll sign them back in to ask for November 7th. We'd sent subpoenas out already.
May I just confirm, you said, Counselor, you're gonna call Fisk, Agar, and who else?
Freudenberg.
Remember.
So November 8th. We'll reset it for November 8th for both. Any objection to that, Ms. Krivelenkoff? I'm sorry, Victoria?
No, I'm okay with it.
Okay, and we've got motions anyway, so we'll be able to address availability of witnesses on those motions. I can't do them this week. I could do either the afternoon, probably the afternoon of the 30th of October works best for my schedule, but I could do a little bit later on the 29th of October for any pretrial motions and nominees.
Okay. What time, are we still staying with 1 p.m.?
Well, I could do 1 p.m. on the 30th if that works, October 30th.
That's fine, that's for the motion, the hearing on the motions.
Yeah, and that would be kind of our readiness.
I cannot wait to hear this guy argue his motions and watch him go down in flames. I just don't know what they are yet.
Okay. And then the trial, are you still,
The trial will be, we're resetting it for November 8th, and then I'll just count readiness as 1 p.m. October 30th.
okay? And the trial is 8:30 a.m.?
The trial will be 8:30 a.m. I haven't had an opportunity to review Victoria Krivelenkoff's motion. She has some in there in her court file. I don't have any motions in your court file, Mr. Krivelenkoff, so if you could get those filed by the end of the week and served on the prosecutor so they have an opportunity to respond. And then finally, I have reviewed and Victoria Krivelenkoff, did you receive a copy of the state's findings of facts and conclusions of law from the last hearing we had?
Is that the one that she filed, she sent me on Friday?
It might be, let me see what the date is. I just got it handed to me today, so let me see if there's a, yeah, it's like a 5-page document that was filed October 21st. So I guess it was filed today, but she might have sent it to you last Friday.
She sent me a, like a mock, it's not official, so it was just a draft.
Yeah.
But I haven't got the official yet.
Okay, it just says states proposed, and so
Right.
we can enter these at the next hearing, but if you'll review them, because if you think something else happened that needs to be included, you can kind of make an objection or indicate that to me so that when we do the final draft, I'll make sure everything's included.
Okay.
Okay, so we can take care of that on the 30th, so I'll hold off on, those are in the court files. So hold on.
Okay, and Your Honor, the state, we're reviewing the tape for the findings and fact and conclusions. The state noted we played a couple videos that we didn't have a disc for. It was just kind of played into the record, and so to make a complete record, the state burned it onto a disc. It's the 2 videos of Sergeant Agars that were played in the court proceeding for the court.
So you want those marked? Did we not, we didn't have any exhibits?
We didn't have any exhibits that day. So, I mean, we ended up having 2 videos played, so we should have probably had a
Okay,
disc,
put that
but
in there. Give it to Nancy and then I'll go
Okay.
for the record. Because if you guys, I don't know how this is gonna go, we have a trial date set, so at the end of it, if there were convictions, ultimately, and the case wasn't dismissed before then, you'd have a right to appeal that decision, so we just wanna make sure the reviewing court sees what I'm seeing, or
Yes.
saw.
And with that, Your Honor, I want to make one note, and that way Ms. Krivelenkoff can look at that as well. The court ultimately found, I think in findings of fact, based on number 10, that Deputy Freudenberg testified that there was a disturbance about 2 hours had passed. The state reviewed the bait stamp or the timestamp in the Axon video, and it was approximately 40 minutes, and that was more of a clarification. I think that the state failed to, or defense failed to ask too about whether it was specific to this incident or the overall incident while they were at the scene. But between the time of when the calls kind of were made and when Ms. Krivelenkoff was taken out of the car, the more appropriate or accurate fact was about 40 minutes. And that is already in the record due to the videos that were played, because the videos revealed the time and date. So that was the only big notation that the state wanted to make for the court to be aware of, just to
Okay.
better clean up the record.
So look at findings of fact number 10 when you're reviewing it, Ms. Krivelenkoff. But we'll discuss it on October 30th. Okay,
All
so,
right, thank you.
okay, Mr. Krivelenka, I do need you to come up and sign that waiver of your right to an attorney only, and that's the one we went over at the beginning. And then we'll print out for you.
Go ahead, Attorney, sir. Can you sign anything else, the dismissal?
Yeah, that's fine. We'll print out for you a copy of the dismissal without prejudice of count 1, this waiver that you just signed, and the 2 court dates that I just gave you, October 30th at 1 p.m. and then November 8th.
at 8:30.
Sounds good.
And then, Victoria, we will email to you, the only thing that changed on yours were kind of the court dates. So we'll email to you a copy of those modified court dates, which are October 30th at 1 p.m. and the November 8th at 8:30.
Okay.
And if I may, Judge, also request a copy of the joint order, please.
Let me sign that out and I will print that out. Did you? Yeah, you did. It's in her file. Did you do an order on joint order?
Your Honor, we failed to. We did a motion and I didn't prepare an order. We could certainly.
Okay, we'll prepare an order. Do you need the motion though to consolidate?
I have a copy of the motion, but.
Okay, I didn't, apparently she didn't attach an order. I assumed it wasn't here because it says, I guess it just says motion.
But we'll draft one.
We'll
for next
enter the
week.
order on the October 30th date.
Okay, that's accepted.
Okay. All right, I think that will conclude everything for today and I will see the parties on October 30th
30th at 1 p.m. Okay.
at 1 p.m.
We adjourn?
You're good to go.
So,
Thank you.
That was his arraignment. Sounded like it went pretty well. You can already tell what he's going to try to pull during the trial. He's going to try to delay and dodge and weave and call witnesses that don't have anything to do with the case. He's going to have all kinds of problems with this, which he doesn't realize yet. I don't see how from the video that this arrest was in, how he's going to get away with this. I just don't see it happening. He may get lucky, you never know. But it'll be interesting to find out. Anyway, that's all I got for you. Love ya. Bye.